on the hook for the full extent, even the unforeseeable extent, as long as the initial type of harm was foreseeable.
Wow, okay. That's a huge rule. Now let's talk about the final element, damages. What does the plaintiff actually need to prove they lost?
In a standard negligence case, the plaintiff must prove actual, legally recognized damages. Usually this means physical harm, bodily injury, or property damage. Nominal damages aren't available for negligence.
Physical harm required. What about emotional distress?
Emotional distress damages are generally recoverable in negligence only if they result from a physical injury, or if the plaintiff satisfies the specific requirements for negligent infliction of emotional distress, an IED, which we'll touch on shortly. These are sometimes called parasitic damages because they attach to the physical harm claim.
What about purely economic loss, like lost profits not connected to any physical injury?
Pure economic loss, standing alone, is generally not recoverable in negligence actions. There are some exceptions, but the general rule is no recovery for just financial harm without accompanying physical injury or property damage.
And attorney's fees?
Generally not recoverable in U.S. tort actions, unless provided for by statute or contract. Each side typically pays their own fees.
So the main goal is compensatory damages.
Yes, the primary goal of negligence damages is compensation to make the victim whole again, as much as money can, to restore them to the position they were in before the injury. The plaintiff also has a duty to take reasonable steps to mitigate their damages, meaning they can't just let their losses pile up unnecessarily.
What kinds of things are included in personal injury damages?
Typically, past and future medical expenses, past and future lost income or reduced earning capacity, pain and suffering, both physical and mental, loss of enjoyment of life. It aims to be comprehensive. And remember, the eggshell skull rule applies to the extent of these damages.
And property damage.
For property damage, the measure is usually the difference in the fair market value of the property before and after the injury, or sometimes the reasonable cost of repairs, as long as that cost doesn't exceed the property's value.
Okay. What about the collateral source rule? Does it matter if the plaintiff's insurance already paid for some of their medical bills?
Under the traditional collateral source rule, the answer is no, it doesn't matter. Benefits the plaintiff receives from sources independent of the tortfeasor, like their own health insurance, sick leave, disability benefits, are not deducted from the plaintiff's damage award. The defendant doesn't get the benefit of the plaintiff having been prudent enough to have insurance.
So the defendant might pay for damages that were already covered by insurance.
Traditionally, yes. The rationale was that the defendant shouldn't benefit from the plaintiff's foresight,
Right.
and sometimes the insurer could seek reimbursement, subrogation. However, it's important to note that this rule has been modified or even abolished by statute in many states now, so it's less common in its pure form. Payments from the defendant's own liability insurer are, of course, credited.
Okay. And when are punitive damages recoverable in negligence? These are meant to punish, right?
Yes, punitive damages are about punishment and deterrence, not compensation.
Yeah.
They're generally recoverable in negligence cases only if the plaintiff proves by clear and convincing evidence that the defendant's conduct was more than just negligent. It was willful and wanton, reckless, or malicious. Ordinary carelessness won't cut it.
So much less common in negligence than in intentional torts.
Much less common, yes. And there are often constitutional limits, like the general rule that punitive damages shouldn't exceed a single-digit ratio compared to compensatory damages.
Okay. Now let's quickly touch on some special rules or specific types of negligence claims that often appear. First, negligent infliction of emotional distress, or NID.
Right. This is where a plaintiff can recover for purely emotional distress under negligence, but only in specific circumstances. The main one is the zone of danger theory.
Zone of danger.
The plaintiff must show they were within the zone of physical danger created by the defendant's negligence. They feared for their own safety due to that negligence, and the threat of physical impact caused severe emotional distress. Most jurisdictions also require that this emotional distress manifests in some objective physical symptoms.
Physical symptoms required.
Yeah.
Okay. What if the plaintiff wasn't in danger themselves, but witnessed a close family member get injured?
That's the bystander theory, the other main route to NA recovery. Generally, a bystander outside the zone of danger can recover if they are closely related to the person injured by the defendant's negligence. They were present at the scene of the injury, and they personally observed or perceived the injury occurring. Again, most jurisdictions require the bystander's resulting emotional distress to cause physical symptoms.
So close relationship, presence, perception, and physical symptoms. Got it. Are there other NID cases?
Yes. Sometimes recovery is allowed in special relationship cases, where the defendant's negligence creates a high likelihood of severe emotional distress, even without threat of physical impact, like a funeral home negligently mishandling a corpse, or a hospital misdiagnosing a serious illness. Physical symptoms may not be required in these cases.
We mentioned pure economic loss isn't usually recoverable. Can you just reiterate that?
Right. The general rule is that purely economic losses, lost profits, lost contracts, etc., that are not the result of some accompanying personal injury or property damage caused by the defendant's negligence are not recoverable. This is the economic loss rule.
Okay. What about actions related to someone's death? Wrongful death versus survival actions.
They're distinct, but related. A wrongful death action is brought by the decedent's spouse or next of kin to recover for their own losses, resulting from the death, things like lost financial support, lost companionship, funeral expenses. A survival action, on the other hand, is brought by the decedent's estate to pursue any claims the decedent themselves could have brought if they had survived, like claims for their own pain and suffering before death, lost wages before death, medical expenses.
So one is for the family's loss, the other is for the decedent's loss.
Exactly. And you can't get double recovery for the same losses through both types of actions.
Finally, these specialized actions, wrongful life and wrongful birth. These sound very specific and probably controversial.
They are, and they vary significantly by state. A wrongful life action is brought by a child, usually one born with a severe congenital defect, against a healthcare provider who negligently failed to diagnose the defect or inform the parents, thus depriving them of the choice to avoid conception or terminate the pregnancy. Recovery, if allowed at all, is often limited to the extraordinary medical expenses associated with the disability. Wrongful birth or wrongful pregnancy actions are brought by the parents for the same type of negligence. Recovery might include the costs of raising the child or just the costs of pregnancy and childbirth, plus emotional distress. These are complex and state-dependent. Vicarious liability and immunities. Who else is responsible?
Okay, so far we've mostly focused on the person who directly committed the tortious act. But sometimes the law holds someone else responsible for that person's actions. That's vicarious liability, right? Sometimes called the deep pockets doctrine.
That's exactly what it is. Vicarious liability is essentially a form of strict liability without fault, where one person or entity is held legally responsible for the torts committed by another. It's not based on the vicariously liable party's own wrongdoing, but on their relationship with the actual tortfeasor, specifically their right, ability, or duty to control that person's activities.
And the classic example is employers and employees.
Yes, the doctrine responded to superior, let the master answer.
Yeah.
An employer is vicariously liable for torts committed by their employee, provided two conditions are met. First, a formal employer-employee relationship exists, not an independent contractor. And second, the employee's tortious conduct occurred within the scope of their employment.
Scope of employment. What does that mean? Does it just mean while they're on the clock?
It's broader than just being on the clock. Conduct is generally within the scope of employment. If it's the kind of work the employee was hired to perform, it occurs substantially within the authorized time and space limits of the job, and it was motivated, at least in part, by a purpose to serve the employer. Minor deviations, sometimes called detours, are usually still within the scope, but major departures or frolics are not.
What about intentional torts committed by employees, like a delivery driver getting into a fight? Is the employer liable then?
Generally, employers are not vicariously liable for their employees' intentional torts. Those are usually seen as outside the scope of employment. However, there are exceptions. If the use of force is part of the job description, like a bouncer, or if the tort was committed in furtherance of the employer's business, like an overzealous bill collector, or if the employer ratified the conduct, then vicarious liability might attach even for an intentional tort.
And employers can also be liable for their own negligence, right? Not just vicariously.
Absolutely. An employer can be held directly liable for their own negligence in, say, hiring an unsuitable employee, failing to train them properly, or failing to supervise them adequately. This is separate from respondent at superior. It's liability for the employer's own carelessness.
What about liability for torts committed by independent contractors? If I hire a plumber, am I liable if they negligently flood my neighbor's apartment?
The general rule is no. A person who hires an independent contractor is usually not vicariously liable for the contractor's torts, precisely because the hiring party doesn't have the right to control the manner and means by which the contractor performs the work. That control is the hallmark of an employer-employee relationship.
But are there exceptions?
Yes, there are important exceptions. The hiring party can be liable if they retain control over the specific aspect of the work that caused the injury, or if the work involves inherently dangerous activities, or if the duty is considered non-delegable as a matter of public policy, like a landlord's duty to keep common areas safe. Also, if the contractor appears to be an employee, parent agency, the hiring party might be liable.
Okay. How about business partners or people involved in a joint enterprise?
Participants in a partnership or a joint enterprise are generally vicariously liable for tortious acts committed by their partners or co-venturers if the act is within the scope and course of the business's purpose.
What about automobile owners? If I lend my car to a friend and they cause an accident?
Several ways an owner can be liable. First, under negligent entrustment, the owner is liable for their own negligence if they lend the car to someone they know or should know is incompetent, reckless, or unfit to drive. Second, many jurisdictions follow the family purpose doctrine. This makes the owner vicariously liable for torts committed by family members using the car with the owner's express or implied permission for a family purpose.
And third,
Many states have enacted owner liability statutes or permissive use statutes. These make the owner vicariously liable, up to certain limits, for torts committed by anyone driving the car with the owner's permission, regardless of family relationship or purpose.
okay, lots of ways car owners can be on the hook. What about parents and their children? Are parents automatically liable if their kid breaks a neighbor's window?
The general rule of common law is no. Parents are not vicariously liable for the torts of their minor children just because they are parents. Vicarious liability might arise if the child is acting as the parent's agent, but that's rare.
So, no automatic liability. But can parents be liable for their own negligence related to their kids?
Yes, absolutely. Parents can be held directly liable for their own negligence if they fail to exercise reasonable care to control their child when they know, or should know, that the child has dangerous tendencies and that control is necessary to prevent harm to others, and they have the ability to control the child.
So negligent supervision, essentially.
Exactly. Also, many states now have statutes that impose limited vicarious liability on parents for certain torts, often willful or malicious acts committed by their minor children, usually capped at a certain dollar amount.
And finally, dram shop liability. This involves selling alcohol.
Right. Dram shop acts, which exist in many states, impose liability, often statutory liability, on sellers of intoxicating beverages like bars or liquor stores when they sell alcohol to someone who is visibly intoxicated or a minor, and that person then causes injury to a third party due to their intoxication.
Does it apply just to commercial sellers? What about social hosts?
Traditionally, it applied mainly to commercial vendors. However, some states have extended liability to social hosts who serve alcohol to guests, especially if the guest is a minor or clearly intoxicated, though the standard for social host liability is often higher, requiring reckless conduct, perhaps.
Okay, so vicarious liability covers who else might be responsible. Now, let's flip that coin. Immunities from tort liability. When does the law grant a shield protecting certain defendants from being sued, even if they committed a tort?
Immunities are situations where, due to the defendant's status or relationship, the law prevents a tort action from being brought against them or limits liability. The most significant area here involves the liability of the government and its officers.
Government immunity. Sovereign immunity.
Historically, yes. The idea that the king can do no wrong. Today, both the federal and state governments have waived this sovereign immunity to some extent, but not completely. The Federal Tort Claims Act, FTCA, allows suits against the U.S. government for torts committed by federal employees acting within the scope of their employment.
But there are exceptions.
Big exceptions. The FTCA waiver doesn't apply to certain specified intentional torts, though there's an exception for law enforcement. Claims arising in foreign countries, combat activities, and importantly, claims based on the government's performance of a discretionary function or duty.
Discretionary functions, meaning policy decisions.
Generally, yes. Decisions involving policy judgment or planning are immune, whereas negligence in the operational execution of a task might not be. It's a complex distinction.
What about state and local governments?
Most states have also partially waived their sovereign immunity through state tort claims acts. But the scope of the waiver and the exceptions vary widely from state to state. Municipalities are typically governed by these state acts. Traditionally, there was a distinction between immune governmental functions and non-immune proprietary functions, but many states have moved away from that.
And individual government officials. Can you sue the police officer or the mayor personally?
Government officials generally have qualified immunity when performing discretionary functions, meaning they're protected unless their conduct violated clearly established statutory or constitutional rights that a reasonable person would have known about. There's generally no immunity for performing ministerial acts, tasks that are merely routine or don't involve policy judgment. High-level officials like legislators, judges, and prosecutors have absolute immunity for acts performed within their official, judicial, or legislative capacities.
There's also the public duty rule. What's that?
This rule generally holds that a governmental entity, like a police department or a fire department, cannot be held liable to an individual citizen for failing to adequately perform a duty that is owed to the public at large, like general crime prevention or fire protection. Liability might arise only if a special relationship exists between the government entity and the individual plaintiff, creating a specific duty owed to that person beyond the duty owed to the public generally.
Okay. Moving away from government, what about intrafamily immunity? Can spouses sue each other or kids sue parents?
Historically, there were broad immunities here too. Interspousal immunity preventing spouses from suing each other in tort has been abolished in almost all states. Parent-child immunity still exists in many states, but it's generally been significantly limited. Usually, it only bars suits related to core parenting activities or exercises of parental discretion regarding care and supervision. It typically doesn't bar suits for things like negligent driving by a parent injuring their child.
So largely eroded immunities there. And finally, charitable immunity. Can you sue a nonprofit hospital or charity?
This immunity has also been abolished or severely limited in most states. Some states that retain it might just cap the amount of damages recoverable from a charitable institution rather than providing a complete shield. So generally, charities can be sued for their torts today. 6. Sharing liability and defenses to negligence. Apportioning blame.
Okay, we've figured out who might be liable and who might be immune. But what happens when there's more than one defendant responsible for the plaintiff's injury? How does the law sort out sharing the blame and the damages?
This is a really important practical area, dealing with apportionment of liability. When multiple defendants are potentially responsible for a single indivisible injury, meaning you can't easily separate out which defendant caused which part of the harm, the rules for how liability is shared become critical.
And the traditional rule, often the default on the MBE, is joint and several liability, right?
That's the traditional common law rule, yes. Under joint and several liability, if two or more defendants are found liable for causing a single indivisible harm, each defendant is subject to liability to the plaintiff for the entire amount of the plaintiff's damages.
The entire amount, even if one defendant was only, say, 10% at fault.
Yes. The plaintiff can choose to collect the full judgment from any one of the liable defendants, regardless of their individual percentage of fault. The burden of sorting out the shares among themselves then falls on the defendants.
That seems tough on a defendant who is only slightly at fault. Have things changed?
Significantly. While joint and several liability is the traditional rule, most jurisdictions have now modified or abolished it, especially in negligence cases. The modern trend is towards pure several liability, sometimes called proportionate share liability.
Pure several liability, meaning?
Under pure several liability, each defendant is liable only for their own proportionate share of the plaintiff's damages, based on their percentage of fault as determined by the jury. So the 10% at fault defendant is only liable for 10% of the damages. The risk of one defendant being insolvent shifts from the remaining defendants under joint and several to the plaintiff under pure several.
Okay, that's a major shift. What happens if one defendant under joint and several liability does pay more than their fair share? Can they get money back from the others?
Yes, that's where the right of contribution comes in. A defendant who pays more than their judicially determined equitable share of the damages can sue the other jointly liable defendants for contribution to recover the excess amount paid. However, intentional tortfeasors generally cannot seek contribution from each other.
So contribution is about sharing the loss proportionally. What's indemnification?
Indemnification is different. It's not about sharing. It's about shifting the entire loss from one party to another, full reimbursement. This typically arises in situations like vicarious liability, where the employer held liable can seek indemnification from the negligent employee, or based on a contract, an indemnity agreement, or sometimes in equity, like when one party's liability is purely passive compared to another's active fault, or in strict products liability cases where a retailer held liable can seek indemnification from the manufacturer.
Okay, that covers sharing liability among defendants. Now let's turn to defenses to negligence that involve the plaintiff's own conduct. How does the plaintiff's fault affect their ability to recover? The traditional rule was harsh, right? Contributory negligence.
Extremely harsh. Under the traditional common law rule of contributory negligence, if the plaintiff failed to exercise reasonable care for their own safety, and that failure contributed in any way, even just 1% to their own injury, then their contributory fault was a complete bar to recovery from the negligent defendant.
Wow, 1% fault means you get nothing.
Nothing. It was an all-or-nothing rule. Very unforgiving. This rule, however, did not apply if the defendant's conduct was worse than negligence, like intentional or reckless conduct.
Was there any way around that harshness? I remember something called the last clear chance rule.
Yes, the last clear chance doctrine was developed as a way to mitigate the severity of contributory negligence, though it's been abolished in most places now, along with contributory negligence itself.
Right.
Under this doctrine, a contributorily negligent plaintiff could still recover fully if they could show that the defendant had the last clear opportunity to avoid the accident after the plaintiff's danger was apparent, and the defendant failed to do so.
So it kind of forgave the plaintiff's negligence if the defendant could have prevented the harm at the very end.
Essentially, yes.
But most places don't use contributory negligence anymore. What's the modern approach?
The vast majority of jurisdictions have replaced contributory negligence with some form of comparative fault or comparative negligence. This seems much fairer to most people.
How does comparative fault work?
Instead of completely barring recovery, comparative fault systems reduce the plaintiff's damages recovery in proportion to their percentage of fault. So the plaintiff's negligence reduces their award, but doesn't necessarily eliminate it.
Are there different types of comparative fault?
Yes, two main types. The first is pure comparative negligence. This is the rule often assumed on the MBE, unless told otherwise. Under pure comparative negligence, the plaintiff's damages are simply reduced by their percentage of fault, no matter how high that percentage is. If the plaintiff is 90% at fault, they can still recover 10% of their damages from the 10% at fault defendant.